很高兴见到你，我是阿部隆德。I would like to thank Professor Xie and everybody to give me the opportunity to give a speech in this prestigious symposium. Professor Tamura already introduced about Japanese system, so I don't think I should add any more, but I would slightly add from the practitioner's point of view. I would like to talk about the current situation, evidence collection, ease of proof of trade secret infringement, proposed amendment, and implication to Taiwan's reform. Let me introduce about the current situation. I understand from the morning session that Taiwan suffers a lot, but we Japanese suffers as well. We share the same hardship, difficulty as with you. Because Korean or Chinese companies entice Japanese employees. Recently, we have two significant trade secret theft cases. In 2012, Nippon Steel and Sumitomo Metal sued POSCO for the trade secret infringement case. And in 2014, Toshiba and SanDisk sued Hynix. Both are Korean companies. Nippon Steel sought $1 billion damage against POSCO, and out of this $1 billion, $0.8 billion, they sought this damage against the individual who is a former employee, because Nippon Steel wanted to show to everybody that trade secret theft won't count. And also, Toshiba sought $1.1 billion. This is a magazine talking about three major Korean companies. It says that the three major Korean companies swallowed Japanese technologies. It says that the Korean makers provide double salary to the Japanese employees to acquire them. Now, as I explained, Nippon Steel filed a lawsuit against POSCO, and former employee of SanDisk was arrested, and the criminal proceeding is still ongoing. He was prosecuted, but not yet the final decision yet. And because he was arrested, Toshiba and SanDisk quickly sued Hynix for the trade secret infringement lawsuit. Now, this is the current situation. Let me introduce the evidence collection in Japan. The civil procedure law provides some menu to collect evidence both before and after the filing of the lawsuit. This is before the filing the lawsuit, introduced in 2003. The party can inquire to the opponent, potential defendant, or ask the potential defendant to produce some documents. However, it is not used in practice because the potential defendant can refuse, and once plaintiff asks this to the potential defendant, they will know that we want to sue them. And as a plaintiff lawyer, we don't want to give a sufficient time for the defendant to prepare. The advantage of the plaintiff is we have sufficient time, but defendant does not. Then if we use this tool, we will lose that advantage. So that's why it's not used in the practice. And famous civil procedure law professor Shindo said that this is totally a failure. Evidence preservation. In Japan, the judges' views are split. One judge was negative. For the evidence preservation to be granted, the possibility of falsification should be existed. Like in medical malpractice, if there is a possibility of falsification of the medical records, judge will grant evidence preservation. But in the trade secret case, one judge says that if trade secret involved, no possibility of falsification and evidence preservation could not be granted. But the other judge is positive. He says even if it's not granted officially, unofficially, the party, petitioner, can ask the opponent to disclose, saying that, okay, we are not going to make it on the record, so please disclose it. It is reported that in the Nippon Steel case, they couldn't find the evidence that there is a theft, but because of the criminal proceedings in the Korean case, the Nippon Steel found that there was a theft, and then they used evidence preservation method in the Japanese court to collect evidence, then filed a lawsuit. In Japan, in the evidence preservation, we do not have protective order, and judicial research officials or technical advisors are not involved in the evidence preservation. I understand in Taiwan, the protective order is, could be applied in the evidence preservation, and the technical examination officers can go with the judge. So I think evidence preservation, Taiwanese system is much more advanced than the Japanese system.